hearing in the appeal of Principal Reporter against Kay.
Ms Clark, you said you had a few more points to make.
Yes, indeed, my Lord. With regard to the child welfare hearing on the 27th of October 06, my submission is that Section 11.2 entitles the Court to grant such orders under Section 11.1 as it thinks fit. In addition to that, my Lord, I would make reference to Section 1.1, which is in connection with the imposition of parental responsibilities. And within the terms of that section, which is at tab 10, reference is made to the imposition of parental responsibilities, but only insofar as compliance with this section is practicable and in the interests of the child. And with regard to the discussion that proceeded before the Sheriff on the 27th of October, it was very much in the minds of those participating in that discussion that the child was now firmly under the jurisdiction of the children's hearing, having regard to the supervision requirement only 1 week before. And the issue of practicability was very much alive in that discussion. And in my submission, the product of that hearing, being the interlocutor of the 27th of October, reflects the provisions of Section 1.1 of the 1995 Act in connection with practicability and is an expression of that.
How long did the hearing last in the 27th?
My understanding, my Lord, is it lasted about 15 to 20 minutes. There is an allocated period of time for child welfare hearings, and there are many scheduled in the day, and that was over the allocation. My understanding is that a child welfare hearing involved in the main submissions by the curator ad litem, and I think that, if I'm correct, that approximately 16 minutes of the allocated time were taken up within those submissions.
How many minutes?
16.
16, well, that's enormously and impressively precise.
Yes, that is time recording,
really?
my Lord,
Really?
by the curator ad litem. The situation,
Was
however...
was that for fee purposes?
Perhaps, my Lord. The situation, however, within those 16 minutes is that was in the form of a dynamic forum, a dynamic discussion between the curator ad litem and the Sheriff. It is a fairly informal forum where the formalities of court are not particularly evident, and the issue of practicability was very much at large in that discussion. And the outcome, of course, was the interlocutor of that day. The interests of the child, as was discussed yesterday, were very much before the court in that hearing. And as my Lord recognised yesterday, within the written case for the curator ad litem at 1.4 is a detail of the various aspects of concern that existed in connection with how to protect the welfare of the child going forward in a situation where jurisdiction was in effect yielded from the Sheriff Court to the children's hearing.
Could you translate for me the note of appearances at page 108? We've got Act McCarthy PP, Alt Conocca PP, and Cal Kelly. I'm not quite sure I've worked out exactly who was who. Page 108?
The curator is Kelly.
The curator ad litem is Miss Kelly.
Yes, right. Curator ad litem, thank you. Yeah.
My understanding is that Conocca PP is a lady solicitor who was representing the appellant.
Right. And Act would be...
And personally present.
Yes, personally present.
Personally present.
Yes.
And McCarthy, I understand, was another...
No, Act must be McCarthy, must be for the husband.
Seeking the
So I'm having various contributions here, but it does seem to suggest party present. And that is, of course, a requirement of a child welfare hearing.
Right, I see.
that part of the intention behind the regime
Yes.
is very much to involve the parties.
Yes.
And there is an obligation upon the parties to be within that forum.
Right.
And McCarthy would be the solicitor who was representing.
So we've
the
got
mother.
both parties present and the curator ad litem and
Yes,
and the parties represented.
that is so.
Thank you.
And of course, what also was an aspect of this forum was the recognition by all parties that it was appropriate that contact continued. So there was no discussion, as far as I understand matters, in contest to that.
Yes.
So my submission, my lady and my lords, is that the interlocutor, being a product of that very full discussion before the sheriff, directed towards the interests of the child, directed towards the overarching principles within section 11.7, and having regard to section 1.1 on the issue of practicability, that there is no defect in that interlocutor and that it is competent.
Yes.
With regard to the third matter, in connection with the reading down of the 1995 Act.
No, you deal with this in your written case at page 12, I think. Is that right? It's really pages 11 and 12. You draw our attention to authority report against S, which we know about.
Yes.
And what I understand your position to be, you support the second of the two alternatives, not the first.
And not the first, my lord. And the reasoning behind that is that the curator ad litem's submission is founded upon the recognition of the Article 8 rights of the child, with regard to respect for family life that is established by the criteria that I think the court and all parties are familiar with, and that is the membership of the same family unit and the creation of a bond, and the de facto family tie that exists between the child and her parents.
Yes.
And the identification of a parent, a party who may indeed be ignorant of that status, does not form an expression of the rights deriving from Article 8. And that the second proposition for the appellant is founded upon the benefits deriving from Article 8,
yes.
and that the child should have the benefit of inclusion within the children's hearing of the parent with whom a bond has been established. The submission is also founded upon the fact that it is a feature of the 1995 Act to include those with a connection to the child and who have a reasonable and stateable contribution to make to the well-being and the future of the child.
As a matter of practicality, how would that be established? Would
Well,
it be the children's hearing that would have to address that question?
It would be the reporter to the children's hearing who would have to identify those persons who would be invited or who qualify in terms of section 93.
But in the case of dispute, it would be for the children's hearing to resolve that dispute, would it?
That may be so, my lord. It ought to be evident, it ought to be apparent, and indeed I think the terms of the proposition for the appellant appear to be those persons who have that de facto tie with the child. So it is what it appears to be evident in connection with the circumstances of the child.
I wonder whether one can be sanguine about the prospect of it not being a contentious matter. Certainly from my very limited experience in family matters, or in this area, it's very frequently a problem in establishing whether or not there is a sufficient family tie in order to rely on Article 8. I just wonder whether the children's hearing is an appropriate forum to resolve potentially contentious and sometimes difficult disputes.
The backdrop to a child going forward into the children's hearing involves very often social work intervention, personnel who are have the capacity to inquire into the circumstances of the child.
There is another aspect to this, which I think the reporter draws attention to, and that is that if somebody is brought within the definition of relevant person, then there's an obligation to attend the hearing, and it's a criminal offence to fail to do so. So one has to work out how this formula would operate in the event of a prosecution being brought. So one has to bear that uncertainty point which is brought against you in mind. I wondered whether there was an alternative way of dealing with this. If you look at your case at page 11, you'll see that in paragraph 3.2, you quote from authority reporter against S. Now, in fact, the quotation is incomplete, because you'll recall that what happened was the division noted that that was the agreed position between the reporter and S, and they added in the words, a right of contact. That is, any parent enjoying a right of contact in terms of a contact order. And I wondered whether it would be possible in a case such as the present, where we know that the father had an interim contact order, to build on that formula and write in the words, this is just thinking out in a way, who has or has had a right of contact in terms of a contact order. The problem being in this case is we know that the interim order was stopped at the critical point which prevented him from going to the children's hearing. And that may be typical of these cases where an allegation of sexual abuse is made.
Yes.
And it might be thought that this would introduce a little more certainty into it, because you've got the benefit of an order already having been sought and obtained in the Sheriff Court, which would, of course, be on the basis of a de facto family tie, I suppose.
Yes, I recognise my Lord's comment clearly, because one of the main issues here for the curator ad litem is the temporary deficiency in the parent because of the suspension of the interim contact order. And I recognise that that is what was the agreed position, and it should say a right of contact.
Yes.
That is a possibility, my Lord, and it may provide an element of certainty, because obviously there will be historic reference to what has in fact occurred. That still requires the parent to be proactive in seeking from the court a court order. There may, however, be a greater ability to obtain, as a natural expression of the relationship between the parent and child in a situation of conflict between the parents, it might be more possible to obtain that order than it would be to obtain the parental rights order that is so elusive in so many circumstances.
Well, I thought I'd mention this now so that those against you might consider whether this would work or not. And it does, of course, mean this. It places the initiative on the father to go to the court and obtain an order. There's a lot of criticism of him for not taking various steps, but he did actually take that step and did get the interim order.
In this instance, that is so. It might not always be so, because children who have parents who can resolve between them arrangements for contact might not be before the civil court.
Right. I know. I appreciate that.
And you have a situation that can suddenly emerge before the children's hearing, where the unmarried father would still be deficient of the requisite mechanism to bring him within the arrangement, and that I would submit is a fear.
Perhaps we should leave it there. I mean, I've just thrown this out as a possibility. One's got to recognise the problem that Lord Kerr's mentioned, and is mentioned in the cases against you, about the lack of precision, which is a consideration we've got to bear in mind.
Could I just come back to the criminal offence point, because that's a point that you make in your case at 3.3 as a reason why the simple solution of just saying parent is not a good solution. I think we have to have in mind that because you're referring to section 45(9) of the 1995 Act, which says that any person who fails to attend a hearing, which he under 8b he is obliged to attend, is guilty of an offence. But 8b does say that a person is obliged to attend at all stages of the hearing unless the hearing is satisfied that it will be unreasonable to require his attendance, or that his attendance is unnecessary for the proper consideration of the case. So it's not an absolute obligation. I appreciate that there's an element, that there would be an element of uncertainty because a person wouldn't necessarily know whether it would be held that it was or was not reasonable or unreasonable for him to attend. But it is quite important to have in mind that the statute very carefully does not impose an absolute obligation.
Yes.
So that the father who had absolutely nothing, had nothing whatsoever to do with his family and with the child, maybe for quite a long time, would be presumably excused attendance.
Yes, I'm obliged, my lord.
So are you prepared to give qualified support at least to the first of the two alternatives that Ms. Scott put forward?
There remains a concern with regard to the identity of a parent and to the involvement of a parent in the life of the child. And whilst, yes, there is a provision that provides excuse for a parent who has no connection with the child, that clearly still has to be qualitatively assessed at some stage in the proceedings. And what is favoured is a recognition of the rights of the child to the involvement of a parent deriving from Article 8.
We understand that that's why you're limiting yourself in a way. You're representing the child.
Yes.
And therefore you're focusing on the child, not on the parent's right to a hearing in the determination of their civil rights, but on the child's right to family life. That's reasonable from your point of view. Others have a different point of view. So we must obviously weigh all those points of view. But from the child's point of view, one of the things that concerns me is that the reason why any father, married or unmarried, may have no relationship with the child is the unreasonable obstruction of the mother. And this is quite a common phenomenon that one sees. They split up during pregnancy. Mother doesn't let father have anything to do with the child. Father desperately wants to have something to do with the child, and the child could very well benefit from that relationship. And the opportunity to enable family life to develop between them. And that's a more common feature in my experience than actually any trouble about who the father is.
Yes, I'm obliged to my lady, and that is a very, very common feature in cases that come before the civil courts. The European jurisprudence, however, takes the interest in the child before birth. It is not just the habits of the parties beyond birth that is the criterion for qualification of the establishment of a family tie. And whilst it might be more difficult for the unmarried father to demonstrate that he has a bond with the child when there has been obstruction and there has been difficulty in the demonstration of that family tie, it doesn't deny him the basis for saying, for example, this child was planned together. It was a deliberate process and expression of family life.
But that's why I'm putting to you that the simple solution.
Yes, it really is an objection to the second alternative, which does require some sort of de facto ties to be established, and that may be very difficult for the reasons mentioned.
And an evaluative judgment.
Yes.
Before you even get to, is there anything to argue about in substance? That's the problem.
Anyway, time has moved on quite a bit, and we must hear from Ms. Wise. And I wonder if there's anything else before you sit down that we ought to hear from you.
I'm obliged.
Thank you very much indeed. Ms. Wise, I think you come next, is that right?
Indeed, my lord.
Lords, my lady, in inviting the court to refuse this appeal, I'm going to deal with the issues broadly in the same order that they have been dealt with to date, and I adhere, of course, to the written case. For the principal respondent, the reporter, which my Lords, my lady, will find in the core volume, and it runs, I think, to some 20 or so pages. If I may...
30, I think.
30 pages, longer than it was originally. So it may be helpful to have that before us when I make my submissions. If I could return first to the domestic law issue, the issue of competency. The sole issue under issue 1 is, of course, whether the Sheriff's interlocutor of 27th October 2006 was competently pronounced or incompetently pronounced and thus appropriately suspended. And my lords, my lady will, of course, have seen the First Division's reasoning on this, which I'm going to come back to. The respondent's position is that there are many orders that the Sheriff could, if satisfied on the welfare test, have granted competently and appropriately that would, as a consequence, have permitted and required the appellant's attendance at the children's hearing. But the terms of the particular order he made, or purported to make, are incompetent and thus appropriately suspended. And I have 4 main points to make in support of this proposition. My first point is that parental responsibilities and parental rights are limited to those listed in sections 1 and 2 of the 1995 Act. It is a comprehensive list, as distinct from the list of orders in section 11.2, which of course is not comprehensive. So that's the first point. The second point is that a grant of parental rights, quote, to the extent that he becomes a relevant person, close quotes, is not a competent order because it does not grant something that is a parental responsibility or right.
Does that mean that it's all right down to and including the words to the extent that, because one might pick and choose between particular rights or responsibilities and identify a particular one, but it's the bit that follows, is it?
It's the bit that follows, and as I'm going to go on to say, one must be careful to distinguish a restriction of grant from a restriction of exercise, and indeed that's my third point, if I may now make it. Yeah. There is a distinction, is my third point, between the granting of parental responsibilities and rights, or any of them, and the restriction of their exercise. The grant can be limited by bestowing only one, perhaps, of the parental responsibilities and rights. So it can be anything from 1 to 4 or 4 to 8 or 5 to 8 if one includes the rights as well as the responsibilities. But the grant cannot be restricted in any way, only the exercise can. So for example, a court can bestow the parental responsibility and equivalent right of safeguarding and promoting the child's health, development and welfare. And then it could restrict the exercise of the grant it has bestowed. It could perhaps restrict it as to forum or to time. So that's the third point.
So could it be done in this case?
It could have been done in this case.
And what would it have been? How would it have run then?
Well, if the appellant had sought an order for a specific parental responsibility and right, such as the one I've mentioned, safeguarding and promoting the child's health and welfare, but restricting the exercise of that so that it was in compliance with any supervision requirement or limited to the period of time the case was before the children's hearing or something of that nature, that would have been competent.
Well, I think I would find it helpful if you could maybe write out for us a form of interlocutor which you say would have been competent.
Yes, I'm happy to do that, my lords, and I will hand that up at the end of my submissions. There are many possibilities.
Yes, no, I know, but maybe you could give us variations which would have been competent, but
indeed.
Something that would be competent on your submission.
I will do that, and it is something, as I'm going to come on to, that the First Division considered whether they should substitute a competent interlocutor, and the reasons they did not do so were because the matter was about to come to proof, and where the welfare test would be addressed, and I'm going to come on to that. But if I may just make the fourth point on this first
Just pausing there, I suppose an interlocutor is open to construction. Is it open to the construction of the kind that you mentioned, that really, although you didn't spell it out in full, it could be read as achieving what you say would have been competent?
I say not, because of the specific statutory creation of parental responsibilities and rights and the need to be clear about whether one is, what one is granting.
But would it have been possible for him to grant a parental responsibility order for the purpose of safeguarding and promoting the child's health, development and welfare, but restricting him that the operation of that to participation in the children's hearing?
Restricting the exercise, yes.
Otherwise, by participating in,
Yes.
in the children.
Yes, but that is a restriction on exercise, not on grant.
Well, quite. But I wondered, is it very far removed from what happened?
Well, as I
What
hope
was
to,
intended? What
yes.
was intended?
As I hope to elaborate on this first argument, when one looks at the terms of the legislation, it is important to identify what one is doing in terms of the legislation and what one is granting, and the distinction, and this was a discussion in Authority Reporter Against S on a slightly different point, but nonetheless I hope helpful, about the difference between the various orders created by the 1995 Act and the importance of not confusing or identifying orders of parental responsibilities and rights that are in fact not parental responsibilities and rights. And that's the theme that's been running through these reporter cases before the different divisions of the inner house of the Court of Session. So fourthly then, the fourth point in relation to this first proposition is of course that the ability to grant any order of parental responsibilities and rights is necessarily restricted by the Section 11.7 welfare test. The order can't be sought for the adult's benefit, only for the benefit of the child. Turning then to the terms of the legislation, and my lords and my lady have looked at these in detail over the course of discussion, but if I could just direct attention again to tab 10 of volume 1, where we see there the parental responsibilities and rights set out at sections 1 and 2.
Yes.
Sorry, where are we looking? I beg pardon.
Tab 10.
Yes. Which sections?
Volume 1,
Yes,
sections 1 and 2, as
you.
we've seen,
Yes,
set
yes.
out the parental responsibilities and rights, and I don't think there's any dispute that these are, this is a comprehensive list, and nothing can be called a parental responsibility or a parental right unless it's in here. There are, of course, different statutory duties on parents that have nothing to do with parental responsibilities and rights. And my learning friend Mrs. Scott referred to some of them. There's the obligation to aliment, there's the duty to educate. But they are not parental responsibilities and rights of the form that we are dealing with in this case. The
Reference is made to section 1.1a
Yes.
by Ms. Clark, and that would be relevant to what we're talking about, at what might take place at a children's hearing, wouldn't
Yes.
it?
Very much.
Yes, but that is absolutely so, that of course one is discussing the safeguarding of a child's development, health and welfare. The difficulty is in conflating the two ideas of that parental responsibility with becoming a relevant person, which is not a parental responsibility at all, but is a consequence that flows from having one or more of the parental responsibilities and rights listed in section 1.
The concern of the reporter for the purity of the interlocutors is admirable, I suppose. But what is the purpose of? What's the purpose of this? If that is all we're concerned with, you're quite content for people in the position of the appellant to be a relevant person.
The position of the reporter is that they seek clarity, and they have onerous duties, obligations to see that only those who fulfil the statutory interpretation of relevant person come before the children's hearing. They are engaged in the administrative burden of convening the hearings, serving on relevant persons, giving them notice. There are different notices, for example, if one's a relevant person and is obliged to attend with possible criminal sanctions, and this has already been the subject of discussion this morning. So the reporter has an interest and a duty in clarifying that those who are in the category of not having parental responsibilities and rights by operation of law, but who require to obtain a court order to have those responsibilities and rights, have properly and competently done so.
And was the order intimated to you? The Sheriff's order?
If my Lord would bear with me. There may be, in order to answer that, I'll require to find out when exactly.
Well, in general terms, when sheriffs pronounce these orders, which from what we've been hearing about, they did at least do not infrequently, presumably they did it in order to come along to the so presumably they had to tell the reporters, by the way, we are going to come along and we are relevant persons and therefore documents and so on have got to be served.
Yes, well that must be right because it's recorded in the decisions of the children's hearing. And I know that the appellant was represented, and I think it will have been through the representation. But
if they do that, what is the difference, from your point of view, between that relevant person and a relevant person who's a dad because he was married at the time? What's the difference?
The difference
what difference
is
does it make?
The lack of clarity in the interlocutor and the way it's framed leads to difficulties for the reporter in deciding who is properly in and who is not properly in. And my learned friend referred to other suspension cases. And this was, I think, in support of a contention that this is a kind of routine interlocutor of a type that sheriffs might make. Now, in fact, of the 8 occasions on which the reporter has gone to court to suspend interlocutors, none of the interlocutors have been in the terms of this interlocutor. Most of them, in fact 7 of them, were purported to be specific issue orders, making someone a relevant person. And there's outer house authority from Lady Peyton on that, saying that that's not a competent parental responsibility and right that can be conferred, and so it's a subtly different attempt, if you like. But that's so this was not a routine order, so it's not a situation where these orders are coming to the reporter and well, what's the problem with them because they seem to achieve the effect that of letting the man into the children's hearing. The concern on the reporter's part is that there have been different attempts to obtain different types of orders, many of which do not appear on the face of it to fulfil the competency test. And that is why...
But if one of these competent ones, which you think there could be, were served on you, there'll be no problem.
No problem at all. And those instructing me have clarified that situation has arisen many times, that they have received intimation of an order of the type that I have indicated would be competent and will give an example of, and they have taken no issue.
There are some orders that are quite straightforward, because I think on the 18th of August, the sheriff allowed the father contact at a contact centre. Now, presumably that order would be intimated to the reporter. Would that be right? I mean,
well, certainly it was known of because it's referred to in one of the children's hearings.
I would have thought, as a matter of routine, that the reporter would require to be kept informed of what was going on in the Sheriff Court.
Yes, of course.
And we see in this one of the 27th of October, one of the features of the order is at the end continues interim contact previously granted.
Yes,
so
indeed.
Again, one would expect that would be intimated to and picked up by the reporter and made known to the hearing.
Yes. And I'm going to deal separately, if I may, with the whole contact order issue.
Yes.
Because, of course, it was the subject of discussion, scrutiny in Authority Reporter against S, and also in light of my Lord and the Chair's comments earlier when we get to the issue of reading down and whether or not it might be necessary in this case. But in relation to the...
Could I just ask you another question?
Yes.
It appears that the reporter knew straight away, or almost straight away, of the disputed order, and was perfectly content to operate on its basis. until father decided that he wanted to appeal against the findings of the children's hearing.
My understanding is that that is not quite the chronology of events, or at least the ratio, or the rationale, rather, behind the reporter's decision. My information is that there's an ongoing process of certain orders of dubious competency, if I can call them that, being brought to the reporter's attention and challenged by way of suspension of review proceedings. This particular one, as I understand it, those instructing me did not consult on for some time. It was not scrutinised in the way that some other ones were quicker.
Why should the reporter care? The Sheriff Court has decided that it's a good idea for Dad to be involved in the children's hearing. Why should the reporter mind about the minutiae of the competence of the order that reflects that?
It rather depends on whether one regards the competency or incompetency of an interlocutor as minutiae in this context. The reporter wishes to make very clear that its position is not one of trying to keep certain people out of the children's hearing. The reporter is concerned with its own responsibilities and duties in the administration of the children's hearing, and including only those who fall within the definition of Section 93.
And those duties are to be found where, Ms. Wise?
Well, in the Part 2 of the Children's Scotland Act.
You'll probably come to that.
Yeah.
The fact is, Ms. Wise, the fact is that this order stood from October 2006 until the challenge was brought in January 2009 in response to the appeal, which has now been abandoned. And the whole point of the suspension that was sought, in a sense, is spent in regard to the proceedings with regard to which it was brought.
Well, my information is rather more that it had been overlooked before, not that it was a response to that appeal.
Well, it was overlooked in the first answers in the appeal. I mean, if one looks at page 178, you accepted the first paragraph, and then in the revised version, amended answers at page 184, somebody took the point. So somebody woke up while this was underway. I mean, we don't have dates for the answers.
Yes, that is absolutely so. I was simply distinguishing the idea that the sort of motive was simply in relation to the appeal. But as a matter of timing, that is absolutely correct. Now, it's been confirmed to me by those instructing that the first time the interlocutor was seen by the representative of the reporter instructing now, the first time that she saw the interlocutor was at the appeal. So as a matter of timing, it was during the appeal, but it was not, if you like, a device in relation to the appeal. It was that was the forum in which the interlocutor was scrutinised. Prior to that, the reporter's understanding was that the father had been granted full parental responsibilities and rights. And I'm going to come to the motion that was made to the court in looking at what was actually granted. But the restriction of personnel attending the children's hearing in the child's interest is an important feature of these child protection proceedings, and I don't think that's disputed. And that's section 43 of the Children's Scotland Act 1995, deals with the limitation of numbers at the hearing.
Yes.
Now,
Yes, but that's a policy point, isn't it? I come back to why I was asking, why should the reporter care? Lots of fathers are there as of right. A court which is seized of the welfare of the child thinks it's a good idea that this father should be there. Why should the reporter really mind, other than bureaucracy?
I can only reiterate that there are three main ways in which a party becomes a relevant person with all the, not just rights, but the obligations of attendance and potential criminal sanctions. One is by operation of law. Mothers, married fathers.
Yes, I understand all that.
But perhaps most significantly, those who have care and control of children are automatically in as relevant persons. Those who are not automatically in my submission, require to obtain not just a court order, but a competent court order.
Yes, I know that's what you say. I still don't understand why the reporter minds. I understand that the reporter needs clarity. In other words, needs to know who should be invited and who should not be invited. That I do understand. But it's very difficult for me to understand why somebody whose whole function is to bring the welfare of a child before a children's hearing should mind about the, as I say, the minutiae of which fathers are in and which fathers are out, provided they have clarity as to who's in.
Well, the only answer I can give to that is to refer again to section 43, which is at tab 10 of the Children's Scotland Act 1995, in relation to what the reporter does in connection with the administration of children's hearing. Section 43, subsection 1 provides that subject to subsection 3 below, a children's hearing shall be conducted in private and subject to any rules made under section 42, no person other than a person whose presence is necessary for the proper consideration of the case which is being heard or whose presence is permitted by the chairman shall be present.
Well, how, if they hadn't seen the interlocutor, how did this reporter, who was so concerned about keeping the numbers down, how did that reporter know that the father was a person who was entitled to be there?
The reporter understood that the father had been granted full parental responsibilities and rights.
Just
that is my
assumed that.
information. That is the information that was given, is what I'm told. So,
And it caused no practical difficulties.
the reporter has consistently, and if this court decides wrongly, so be it, but the reporter has consistently taken the view that as a responsible public authority, it should have regard to whether the interlocutor is competent and thus whether someone who doesn't have parental responsibilities as operation of law has properly obtained an order
if
for
and when it
entry
looks
to the
at the
children's hearing.
interlocutor. If and when it looks at the interlocutor.
When it looks at the interlocutor.
Forgive my ignorance, but I'm about to display yet again about all these, to me, slightly arcane procedures, but would it have been possible if the interlocutor, when it looked at the reporter, when it looked at the interlocutor, had misgivings about its form, but was nevertheless satisfied that there was sufficient information before the sheriff to make a competent order, and that a competent order was appropriate, would it have been possible for the reporter to go back to the sheriff to get him to regularise the order?
Well, the reporter isn't a party to those proceedings.
Well, is there no means of getting it back to the sheriff to change the form?
The matter came before the sheriff on numerous occasions, but mostly in relation to the dispute between the mother and the father, not in proceedings involving the reporter other than on the 11th August 2006, which I'm going to come to when the
So you
grounds
can't
for
get
referral
back to
were
the
established.
sheriff and say, look, I'm sorry, could you just change this so that we can get on with it?
I don't
That's not
see why
possible.
the reporter couldn't have made his concerns known to the parties, to the case, and say, look, and they would tell the sheriff that you should be aware that the reporter's unhappy about the terms of the interlocutor. Could it be reworded in a way that would make the position clear? I mean, there are means of communication which I would have thought were open.
And in the end, you could have applied to intervene or something.
Yeah.
I mean,
And why not communicate with the curator?
There is some case law on the difficulties of the reporter intervening, I think, in Part 1 proceedings. Of course, it has to be accepted that there were other routes, but this is the route that the reporter took. This is the route that the reporter thought was the responsible course to bring to the court's attention the concerns about the interlocutor.
It's in a sense the nuclear option. You go to the Court of Session with a petition for suspension, but what's being suggested is that there were ways which it could have been dealt with much earlier and much simpler.
Yes, well, I can't shirk from that. I mean,
well, not earlier, since you hadn't even bothered to read the interlocutor until the appeal was underway.
Well, I don't want to prolong the fusillade which you're barely standing up to, but this is relevant to my mind, and again, this is born of ignorance, no doubt, because according to the appellant, it hadn't been part of the respondent's case that the overarching principles hadn't been considered by the sheriff, and that the sheriff didn't have sufficient information to make a competent order. Of course, what one must not lose sight of in all of this is the need for expedition when you're dealing with the welfare of the child.
Of course, there is a need for expedition, and the availability of interim orders and the child welfare hearing system it provides that expedition in my submission.
Well, it may do as a matter of theory, but it seems to have broken down in this particular instance. That's why I'm interested in what I accept as an intensely pragmatic solution here. Could it not have been possible, if you were satisfied that the sheriff had sufficient information and you didn't dispute that he'd had regard, this experienced sheriff, to the overarching principles, instead of taking the point at the inner house, to go back and get the sheriff to correct it?
Well, clearly these are matters that those instructing me should perhaps consider, but in this particular case, we are stuck with the facts that we have, which are that
expression, beloved of civil servants, we are where we are.
We are where we are.
You certainly can't rewrite history.
I can't rewrite history. I can simply do what I can to assist the court as to how the matter has gone.
Can we be quite, I mean, you've very understandably focused on the terms of the interlocutor, but are you still maintaining the position that the sheriff failed to address his mind to section 11.7? Because that's a separate issue, of course.
It is a separate issue, and my answer to that is this. The appellant presented the argument as if that was the central ratio of the inner house decision, and thus the inner house has erred. I say that is not the position. The position of the reporter throughout was that interlocutors should be clear and unambiguous, that this was not, the sheriff had not, with the best of intentions, had not granted something competent. Now, the part of the First Division's decision that I think wasn't perhaps referred to, although I think Lord Hope may have drawn attention to it at some point, the ratio of the decision actually starts at page 16 in the appendix of the core volume. So we have the decision of the court, the opinion of the court starting at page 2 in the appendix.
Yes.
And then at page 16, under the heading Decision, Competence, we have the ratio of the decision. And it is as follows. 1, that interlocutors should be unambiguous, and there was a problem with that. And that there should be no reading down, and they must mean what they say. If they are ambiguous, they must be corrected, recalled, or otherwise dealt with in accordance with the practice and procedure applicable to appeal and review. So this was a review of an incompetent interlocutor that the First Division agreed.
Are all ambiguous interlocutors incompetent? I shudder to think how many must have been issued by divisions of the court and by this court or the House of Lords in its time. I don't think we ever thought they were incompetent. They might be corrected, they might be this, that, the next thing. People might have to work out what they meant, but incompetent, no.
Well, in my submission, what the First Division, the view the First Division is expressing here is that where you are attempting to bestow rights on people, then it is particularly important that that is done in a competent manner, and where you have a piece of legislation that prescribes what orders you can grant and is a comprehensive list of those orders, then it would be incompetent to go out with that.
And you're using this word incompetent not to mean wrong, but something which is outside the power, is it?
Yes.
I mean, this is it seems to me, and I think probably all of us, really rather extraordinary proposition, that any error is something which is outside the power of the court or the decision maker to make.
But it's not any error.
Well, you're citing as an example ambiguity.
In my submission, the reference of the First Division to ambiguity must be read in conjunction with this being an interlocutor purporting to bestow a right on someone who doesn't have that right by operation of law. So it's not a simple error or a simple ambiguity. It is something that is out with the scope of the statute, and that was the First Division's concern with it. And the ratio of the decision goes on that there are a number of problems with the interlocutor. It's phrased as if it were a final determination, giving the father parental responsibilities and rights, although they regarded that as perhaps more technical and could have been corrected. But more importantly, in paragraph 60, the decision goes on, the interlocutor does not specify what parental responsibilities and rights are being granted. It is significant that the interlocutor does not grant full parental rights as requested in the motion and crave. Rather, the word full is presumably intentionally omitted from the order. The lack of specification is a more serious defect, that it may not of itself render the interlocutor incompetent. What renders the interlocutor incompetent, in the view of the First Division, is what follows next. And the analysis of the 1995 Act set out by the Sheriff Principal in T against A, and the fact that in determining whether a father should have parental responsibilities and rights, one factor might be that a consequence, and I'm now jumping to paragraph 65, although I can go back if we want to look at this in more detail, that although a consequence of determining whether a father should have parental responsibilities is that the grant will carry with it the right to be child at the children's hearing, the right is not defined responsibility or right in terms of the 1995 Act. Now, the primary ratio, and my lords and my lady will accept this or not, but the primary ratio of the court in relation to competence is in these passages, and that is my answer to the point about section 11.7, that it is simply in the context of whether the sheriff made a competent order, and the primary decision of the court was that he had not made a competent order for the reasons set out principally in paragraphs 61 through to 66.
What about the last sentence of 67?
Yes.
You see, that whole paragraph is speculating as to what actually went on at the hearing. Now, it does seem very strange, particularly if the curator was there, that there wasn't discussion. I mean, quite apart from trying to understand what the facts actually were, yes. One's trying to just take a common sense view of what must have taken place. Yes. One would have thought there would have been a discussion about these matters.
The difficulty seems to have been, and this is recorded at paragraph 67, that no party suggested that at the child welfare hearing the sheriff had addressed or been invited to address the three overarching principles. Now, I understand, and this is no part of the reporter's case, but I understand that there is a dispute, in fact, between some of the other parties in the case, in particular.
Do I gather from the way you've been approaching this, you're not really taking that point? Is that a fair assessment?
That's a fair assessment, my lord.
Yes.
It wouldn't make the order incompetent.
Well, it's not.
It's nothing to do with competence.
Yeah. It is not a matter that was put forward by the reporter.
I know, absolutely, Miss Wise. I'm not suggesting for a moment that it was.
Yeah. The reporter's argument was accepted by the court in the preceding paragraphs.
Well, you say that, but in fact, the only paragraphs in which the court unambiguously says that this order was not competent are 67 and 68. They don't say. They say it could make it incompetent, but they don't say that it does.
My submission is that one should read the whole decision from paragraph 58 right through to 68, and it becomes clear in reading the whole ratio that what the court decided was, one, that the order was incompetent because an order that purports to grant a right of becoming irrelevant person is not a right as defined by the Act, and thus is not, it can't competently be granted. And they then said further that there were difficulties with the interlocutor because no one was suggesting that the overarching principles had been addressed. And although that was not part of the reporter's submission, it's accepted by all parties in this court that, of course, the welfare test must apply to any order.
Yes, but failure to do it doesn't make the order itself incompetent. It's a perfectly competent order. The question is whether or not, before making it, the court has gone through the hoops, and that's a question which, of course, you raise in appeals and so on. It doesn't make the order incompetent.
It is a matter that concerned the First Division. I rest on the argument made before the First Division and here that the ratio insofar as it is concerned with whether the court had power to grant the order that it did because of the very specific terms of the legislation. And I say that is enough.
In other words, it's the nature of the order made rather than whether the precondition was satisfied. That's your principal argument.
That is my argument.
And you were saying, do I understand, Ms. Wise, that at the hearing the submission was made that there were ways in which it could have been done competently?
Yes, absolutely so. That the reporter has never suggested, nor could it. There would be difficulties with the compatibility argument if it had done. The reporter cannot suggest that no competent order can be made, a consequence of which is that a father in the appellant's position goes to the children's hearing. The focus was always that a sheriff requires to be very clear about what orders he is making. Now, I think Sir John asked yesterday a question about the actual application, the motion that had been made to the court that the sheriff did not grant in whole but purported to grant in part. And lest that be of interest, we see that at paragraph 11 of the First Division's decision, where they record many of the background facts. And one requires to read this in conjunction with page 108 of the core volume appendix to see that it is the same motion. So at paragraph 11 of the First Division's decision, it's recorded that 21st March 2006, the case called in the Sheriff Court on the father's motion, which was in 3 parts: 1, to recall the cyst; 2, to make an order granting the father full parental rights and responsibilities in terms of Crave 1, and 3, to ordain the mother to appear, etc. Now, that motion was numbered 7.2 of process, and it is the motion ultimately said to be granted in part at page 108 in the interlocutor of 27th October 2006. So when one reads the decision of the First Division and what it sees as the significance of the motion being for full parental responsibilities and rights, and then the sheriff purporting to grant it in part, and the restriction being as to grant and not exercise, that is the motion being referred to. Now, I have...
So they're not actually strictly correct in the sentence that follows. Oh, sorry, yes, they're correct that the cyst was recalled. Yes. So
they say only part 1 was granted at that time.
Yes,
and then what ultimately the sheriff was determining in the October was the continued parts of the motion, and in particular, of course, substantively part 2. Now, the other submission I wish to make in relation to this part, and this flows through the whole argument, and when one looks at the compatibility arguments, its significance will, I hope, be clear, is this. In the scheme of the Act, only the court can grant, vary or revoke parental responsibilities and rights. Children's Hearing has no power to do that. It has never been the function of child protection proceedings to be concerned with the rights of parents, and decisions on that have always been reserved to the court. What the hearing can do is temporarily suspend the operation of rights imposed by the court. And I'll be inviting my lords, my lady, to look at the interlocutors in the case litigated by the appellant in the Sheriff Court here, where we will see that that is precisely what happened in this case, that the sheriff made orders and the sheriff revoked contact. The children's hearing did not suspend contact in this case. The contact order had been revoked by the sheriff. My learned friend for the appellant referred to Aiken against Aiken in this context, but if I may, there is a passage.
Would you like us to look at that then? That's Aiken in volume 1 of the authorities.
Yes, it's in volume 1, tab 3, my lord.
Yes.
Although this is a case under the previous legislation, the 1968 Act, it's specifically referred to with approval in P against P, which is an important decision. And my learned friend went into the background of this, and I don't want to take time reiterating it, but in the opinion of the then Lord President Emsley at page 302, I think there's some clarity is given as to how this works. So he's discussing at the top of page 302. I'm sorry, do my lords and my lady have that? It's tab 3.
Yes, sir.
Yes. So at the top of page 302, Lord Emsley is discussing the then legislation, the 1968 Act and its scheme. And he says the following: the Act is not concerned at all with the question of the rights of parents or the right of an individual to whom custody, as it then was, of a child has been awarded. It is concerned with Part 3 only, in Part 3 only with the provision of compulsory measures of care for those children who need them, and it is perfectly clear that in pursuit of the objective of this part of the Act, and in terms of section 44(1) thereof, a supervision requirement may be made in respect of a child, notwithstanding the rights of his parents or the rights of an individual to whom his custody may have been awarded by the court. Part 3 of the Act and section 44(1) are concerned not with parental rights or private rights of custody, but are part of a distinct and separate code concerned only with the provision of care for children who require it. Custody and the care of a child with which Part 3 of the Social Work Scotland Act is concerned are quite different concepts. The existence of parental rights in relation to a child or of rights to his custody do not and cannot disable a children's hearing from making a supervision requirement in respect of a child who, on any of the grounds specified in section 32(2), is in need of compulsory measures of care. The making of a supervision requirement does not deprive parents or a person to whom custody of a child has been awarded of their rights in relation to a child. It is properly to be regarded as just another of those lawful orders which may temporarily prevent the exercise of those rights. And that is the passage that has been referred to with approval in subsequent cases. Parts 1 and 2 of the Children's Scotland Act 1995 don't operate as separate and distinct schemes. I think my learned friend said that her attack, if you like, is on the link between the two. But the children's hearing has no power, unlike the court, has no power to impose conditions on any person other than the child. So its role is a very different one, and all of the court's jurisdiction in my submission is retained. Now that brings us to the case of P against P, which is in volume 3 of the authorities at tab 38. P was referred to, but my submission in relation to P is that there's a central ratio in P following from Aiken, that the jurisdiction of the court is never ousted where there are Part 2 proceedings. And the question of what orders the court can appropriately make when a supervision requirement is in place depends on the facts and circumstances.
So I'm slightly lost. Where is this submission going?
Well, where this submission is going is that I say that on the facts of this case, the appellant always had a forum. He always had an opportunity to go to the Sheriff Court, to counter allegations, to seek a proof, and to be involved in decisions about the welfare of his child.
What would it profit him to do that if, meanwhile, there was this supervision requirement?
Well, the supervision requirement, when it was made, did not seek to suspend contact. Contact was revoked by the sheriff. So it was the act of the sheriff that revoked the interim contact granted. And an act of the sheriff.
What opportunity did, I thought, I don't know, but we looked at the order, looked at something on page 162.
The 5th of May was the suspension of the contact order, wasn't it?
The contact order was revoked in August of 2007. It's at page 116.
Yes, and that was following a decision of the Children's Hearing on the 13th of August.
No.
I think, page 161, 162. And I thought that was what we were told yesterday, maybe wrong. Which ends up on the following page with a slightly ambiguous thing about continue the supervision requirement, terminating contact with James Kearney.
Yes, I think there may be a difficulty with the chronology here, my lord, and I want to be absolutely clear about this.
I'm sorry, I may be wrong. I thought that was what we were told yesterday, but that may be wrong.
Yes, as I understand it, the date that was given yesterday for this decision of the Children's Hearing was the 17th of August 2007.
13th was what was given yesterday, I wrote down.
13th, I'm obliged to my learned friend, I had it noted as the 17th.
Yes,
in any event, it post-dated the decision of the sheriff to revoke the interim contact order.
Well, if he had got the contact order restored, what impact would that have on the supervision order?
Well, this is why I say the decision in P, which I'm going to come to, is relevant, and that when one analyses what involvement in the decision-making process the appellant has had in this particular case.
But I'm sorry, this is genuinely in the spirit of inquiry. What would happen? Let's suppose you've got the revocation of the contact order, then a supervision order,
Yes.
and then a restoration of the contact order.
Yes.
What effect does that have, if any, on the supervision order?
Yes. Well, the reason I'm coming to P against P is to answer this question, and what I say is this. There was a forum, namely the Sheriff Court Part 1 proceedings, if I can call them that, in which the appellant was litigating about two connected things. First, his claim that he should be awarded full parental responsibilities and rights, and secondly, a claim that contact should be regulated in terms of a contact order. On the authority of Aiken and P, there has never been anything to stop the sheriff, having made findings, either favourable to the appellant or otherwise, from either granting or refusing crave 1 of the initial writ. You see, the argument for the appellant is that the jurisdiction of the sheriff is excluded. It's over. He's
No,
not
she
able
never
to
said
grant
that.
orders.
She never said that.
She said that sole control was the expression used. Sole control had been given to the Children's Hearing,
Well,
and I'm attempting to answer that point.
It struck me, I may be quite wrong about this, but it struck me that the critical interlocutor was what we see at page 104, which is the 5th of May 2006. And this is very shortly after the social worker had referred the matter to the reporter. And you see that the sheriff there suspends the interim order previously granted. It had been there for 2 years or so. He appoints the Siobhan Kelly to report and directs that Siobhan Kelly is to produce this report and so on, and continues the child welfare hearing to a later date. But what we do know is that in the meantime, steps are being taken to bring the matter before the Children's Hearing.
Yes.
And the point that one, at least for myself, I keep coming back to, is that the Children's Hearing then is going to proceed upon a narrative of facts,
Yes.
which will be open to challenge by a particular route which depends upon the father, amongst others, being in the position of being a responsible person and can therefore be at the hearing, and then if he wants, take the facts to the sheriff for determination. Now, one surely has to see how these two routes interlock. The sheriff is still there in part one.
Yes.
But the very important proceedings going in part two on a narrative of facts which the sheriff can't touch unless somebody refers the matter to him for determination. Is that not right?
That is absolutely right, my lord. And what I say is that the interplay between the two proceedings allows the appellant at any time to seek an order, a consequence of which would be that he participates in the children's hearing process.
But it may be too late, may it not? I mean, if as we know, what happened was that the sheriff actually finds the grounds of referral established. That's the 11th of August of 2006. There's no way back, is there?
It is part of the narrative, of course, that as a matter of fact it was 11th August, but looking at the interlocutors, of course, the matter is live before the Sheriff Court and the appellant has the ability to ask for that order and to ask for it ad interim and to ask for it at a child welfare hearing. So the interplay between the two sets of proceedings, in my submission, doesn't prevent an appellant, such as the one in this case, obtaining the order that the legislation requires him to obtain in order to access the children's hearing. Now, a point was made by the curator ad litem in relation to the perspective of the curator ad litem appointed in the Sheriff Court proceedings, and from the perspective of the child and the concern that from the child's perspective the father should have been represented. But I ask my lords and my lady to note that in the proceedings before the sheriff, where the grounds were established, there was a separate curator ad litem appointed for those proceedings.
Do we have a copy of the interlocutor of the 11th of August?
Yes, it's at page 156.
156, okay.
Yes.
Yes. Yes.
Could I ask you this, because it's relevant to what we're just talking about?
Yes.
Supposing in the course of the private law proceedings going on in the Sheriff's Court, which you say, of course, can continue, of course they can continue, the question is what impact, if any, they have, other than becoming a related person, they have on what goes on in the children's hearing. Supposing that in the course of those private law proceedings, Dad had said, look, there are all these allegations that Mum has made against me.
Yes.
I deny them.
Yes.
And it's in the interests of my child that the truth be determined. So let's have a trial to determine the truth of those things. And supposing in the private law proceedings, the sheriff had decided that those allegations were a complete fabrication and done for the purpose of getting the father out of mother's life and out of child's life. Not an unknown scenario. I'm not saying it's here, but it's not unknown. What impact would that have on what went on in the children's hearing? Because the children's hearing has already got the finding of a different sheriff in different proceedings that the grounds of referral are established.
Two points, if I may, in relation to that. The first point is that the established grounds of referral do not make a finding that the father had subjected the child to some sexual abuse. They simply make a finding that the mother had stated.
This is true, I have read them.
Yes,
I know that's what they say. That's what they say.
Well, in
but then you read the reasoning of the children's hearing at later hearings and you understand that they are proceeding on the basis that that is true.
The context of these child protection proceedings is, of course, that the child's welfare is suffering because of, on the face of the grounds for referral, hostility between the parents, behaviour between the parents, and then there is at the end an allegation made by the mother. The grounds themselves do not seek to prove the truth of that allegation, and it is an important part of my submission that at any time the appellant could litigate the
Well,
truth
supposing
or
that-
otherwise
supposing
of
that
those
they-
allegations in the sheriff
to-
court.
Just to go back to Lady Hale's question, supposing that they litigated that matter and the
Yes.
sheriff came to the view that that was not true, in other words, that the child had never said that at all,
Yes.
and that the mother was lying on that. Now just suppose that. What then?
Well, two possible consequences would flow from that. The first is that it would appear likely that the sheriff would grant the order for full parental responsibilities and rights that the father was seeking. Let's, on the hypothesis that the father is completely vindicated and indeed has led evidence to show that he ought to be part of the decision-making process for the child and that he is well equipped to look out for the child's welfare, and perhaps the mother is not, as a possible consequence, then he might be granted the substantive order of Crave 1, and the sheriff may make a direction that in those circumstances, and this is why I wanted to come to P against P, where they're very careful to say that it can't be said to be incompetent as such to make any order, including a contact order, just because there is a supervision requirement of no contact, because matters will change, the child's life is fluid, different facts may be established, and there may be circumstances, and in my respectful submission, the example given by Lady Hale is a very good one, that matters may move on to the extent that in the forum of the sheriff court, the father may vindicate his position and the children's
So
hearing
which
would
do
have
they
to
obey
take
then?
that on board.
Which do they obey?
Yeah. So
Which
what
do they
happened?
choose between them?
Well,
The children's panel says, no, you mustn't, and the sheriff now says, yes, you must. Which do they obey?
But that is why I make the submission that orders for parental rights can only be granted and revoked by the court. So all the children's hearing has done, if at all, and then I say in this case it was actually the court, not the children's hearing, but leaving that to one side for the moment, all the children's hearing could ever do is say that order for contact, or whatever it might be that the court has granted, as a condition of a supervision requirement to protect the child, we want operation of that suspended meantime.
Yes.
The establishment by the father of findings after proof in the sheriff court would illustrate to the children's hearing that that particular condition was no longer apposite.
So the answer is the children's hearing would respect the findings of fact made by the sheriff in the private law proceedings. Is that what you're saying?
Indeed it is.
And suspend the supervision.
Yes, just as, well, the child might need supervision for other reasons, but on the hypothesis that no supervision is required because the whole thing had been made up, if you like, then of course, and there are examples in these proceedings of the children's hearing respecting the orders of court in particular circumstance. The children's hearing only seeks to suspend the exercise of rights granted by the court where there's an immediate need for child protection.
Yes. So technically, I mean, just looking at the legislation,
Yes.
the position seems to be this, that under Section 68, on the direction of the hearing under Section 65, I think it is, there's an application to the sheriff to establish the grounds of referral.
Yes.
Now, those grounds are held to be established. There's a way back for review, I think, under Section 85, but it doesn't do any more than that. It doesn't allow somebody who wasn't present with a right to be heard
Yes.
to come back later and say, I have a right to be heard. There's provision made, I think, for new evidence and so on, but
Yes.
this isn't that kind of point. But you say that in practice, although the two parts seem to be separated in this respect, in
Yes.
practice, the children's hearing would be informed by the reporter of what the sheriff had actually found on inquiry.
Yes, indeed. And I've also asked those instructing me about the situation where grounds were established without the father's presence and the father then became a relevant person.
Yes.
Because he obtained an order for parental responsibilities and rights. And I'm informed that they would see that as an appropriate reason under the Section 85 test.
To go back for a review.
To go back for a review.
I see.
Just, owners will bear with me, just trying to find the provisions of 85.
In fact, it wouldn't have been reasonably available, or whatever it was, you say.
Exactly, so that's the provision I was looking for.
that sort of thing.
It's been confirmed to me that they would regard that,
That's
of
how
course,
you
as
would-
something that wouldn't have been reasonably available. So yes, I'm obliged to my lord. Now, I hope with that clarification...
Now, I'm responsible, I think, for having interrupted you.
No, not
time
at
ago,
all, my
because you were
lord.
going to give us 4 points, and I've noted 3 of them, and we've been discussing the 3rd one. Was there another one that you were going to
Well,
list?
what I wanted to do at this stage was take, my lords, if I may, to P against P again.
Yes, right.
Yes, right.
I think the submission I just made was that the central ratio of P is that the jurisdiction of the court is never ousted. And I think my Lord Roger understandably had questions about the relevance and significance of that to the current...
Would you mind just reminding which tab it is, please?
It is tab 38,
Thank you very much.
Lord. And the particular passages that I would invite the court to consider are at pages, or perhaps simply the passage at the foot of 788 is sufficient for this purpose, just to focus the particular argument and concern about this issue of, well, if you go back to the sheriff and can you seek your contact order if you get findings in fact and so on. At F on page 788, the court expresses the following view. We find no difficulty with the proposition that where a supervision requirement incorporates a requirement upon a child preventing or limiting contact between the child and another person, any order applied for from the court which sought in effect to vary or discharge that additional requirement would be inappropriate and in that respect could be incompetent. But that is not said to be the position here. We can find nothing in the provisions of the 1995 Act, nor in the cases cited, which justifies the conclusion that without any further inquiry, the sheriff was correct in holding that the second defender's application for a contact order was incompetent. So, as I understood the questions being asked of me, it was, well, what if there is an inquiry? And what if that inquiry takes place in the sheriff court? And I say then you're in the territory of being able to make an order, which would then be taken into account by the children's
You couldn't
union.
actually vary is that what they're saying?
Yes, there's no need to, you can't vary the supervision.
They say it would be incompetent to do that.
Yes, but what you can do is conduct a separate inquiry into the facts.
And then
Yes.
that inquiry then is, the result of the inquiry is made known.
Yes. And that is something there is routinely knowledge passed in relation to Part 1 proceedings, where there are also Part 2 proceedings. And we see that in the facts of this case, when at the time of the initial referral, it was noted that contact was in terms of the operation of a court order.
And do I understand from what they're saying at the bottom of 788L and so on, that an action in this kind of case would be intimated to the reporter and so on, is that right?
Well, it would be known to the reporter.
Right, but they say would be required to be intimated to the local authority. That's it. They're talking about people having
Yes,
parental
I think the local authority would have intimation because under the supervision requirement, that's the local authority is the responsible body, but the reporter, of course.
Well, it says just as the reporter has done in the present case. So in P&P, the reporter had intervened.
Yes, I'm sorry, my lord, I'm not focusing on the passage.
It's just, sorry, it's the very bottom of
Yes.
788, top of 789, column 1. It's just at that, just very... So the reporter had come in and...
Oh, yes, I'm so sorry.
I'm sorry, Ms. Wise.
Local authority would be entitled to intervene just as the reporter has done in this case. Yes, so either the local authority or the reporter. And again, part of the ratio of P against P is, of course, the interrelationship between parts 1 and 2 of the Act. And I'm conscious I don't want to take up too much time with this, but if my lords read, for example, the passage at the top of page 786 right through to 787 at F, we see their comments on the scheme of the Act and the basis for the proposition I have made that the court's jurisdiction is never ousted.
Yes.
And it may be conscious of the time as I am that I should move to compatibility reasonably quickly, but there was one other point in relation to competence, simply for my lords to take away with them is that It seems in relation to the interlocutor, it purported to grant parental rights and responsibilities to the extent of becoming, but once one examines the parental responsibilities in section 1 and sees that they include the right to have the child residing with you, it becomes clear that it couldn't have been an order granting all of those parental responsibilities and rights. And so that was a point I ought to have made when dealing with the basic competency argument, and I simply ask that it be noted. Now, unless there's anything else with which I can assist in relation to the competency argument, it may be preferable for me to move to the issue 2, the discussion of compatibility.
Apropos the point that you have just made, Ms. Wise, there are plenty of parents who have full parental rights and responsibilities, which include the right in section 2 to have the child living with you. But of course that right is subject to a court order saying the child will live with somebody else.
Yes.
That's a common situation.
Yes.
So I can't see how there's anything wrong with an order that produces this common situation.
Well, I was drawing attention to the right to reside because it can't be said that the sheriff was purporting to grant that particular responsibility, and that's just a point in relation to the way in which the wording of the interlocutor. But I think that...
It's back to the nature of the order.
It's back to the nature of the order, and it was a point that I ought to have said earlier, and for the sake of completeness, I make that submission also. If my lords would just bear with me a moment. Yes. Yes, just on perhaps 2 or 3 very short points in relation to the chronology as identified by my learned friend Mrs. Scott, who talked of 4 stages of the proceedings, I think, under this chapter. What she called the first stage was May 2004 to May 2006, when she says during that whole period the appellant was looking for parental responsibilities and rights. And I say that is helpful to my argument in that he was in the right forum, he just had to seek the right order, and won't go over the ground perhaps about the right order again, but that is simply a point in the chronology that I say is something that should be considered. I have already indicated that the contact order was revoked by the sheriff and not suspended by the children's hearing, having been corrected that it was the 13th, not the 17th, but still the sheriff's interlocutor preceded that. And in relation to when the appellant could have gone to the sheriff to litigate the matter of the allegations, of course, that could have been done at any time during all of these stages, and in particular during the years 2007 and 2008. In my submission, the First Division's decision should be understood in the context of that court having before them an interlocutor of November 2009 that indicated that a 5-day proof was to take place in the January. So there is a real context for my argument that these matters were very much within the jurisdiction of the sheriff and to be litigated before him.
Which interlocutor are we now talking
Yes, that's page 126. And of the appendix in the core volume, and that interlocutor in my submission explains the content of paragraph 70 at page 19 of the First Division's decision.
Sorry, I didn't pick that up. This is
Yes,
paragraph.
I'm sorry, if it's possible to have both those pages in front of one. That's page 126 is an interlocutor of 10th November 2009.
Yeah.
And by that interlocutor, the sheriff, having heard both parties in the cure ad litem on an opposed motion, assigned 5 dates in February 2010 as a 5-day diet of proof previously allowed. And that is a 5-day proof on the pleadings, which include all of the complaints by mother against father and vice versa in the Sheriff Court case, and there is a copy of the pleadings in the appendix. So that interlocutor had been very recently granted when the matter came, pronounced rather, when the matter came before the Inner House later that month. And the reference I was making to paragraph 70 of the First Division decision, which is at page 19, my lord.
And just to note at page 4 that the case was heard actually on the 17th and the 18th, so it's just a few days after.
Yes, and the court attention was drawn to that interlocutor, and it is in that context, in my submission, that the comments at paragraph 70 are to be understood. And there the First Division opines as follows. The court has considered whether it might be possible to alter the interlocutor in some way, for example, by suspending it in part or substituting different words. After all, the practical reality in this case may be that some parental responsibilities ought to be imposed in the particular circumstances of the case. However, the court is conscious that it has not seen the background reports or heard submissions. It doesn't have the necessary material, that's welfare material. Furthermore, the court goes on, there is now a proof set to take place in less than 2 months' time. In those circumstances, it seems appropriate to leave it to the sheriff to take, after full consideration, a decision on the merits of the father's case in the Sheriff Court action. And I hope that gives some context to my submission that the rights that the father was seeking were being litigated in the Sheriff Court in an ongoing way, and there was nothing in law to prevent that.
Were you suggesting that there was any reason not to grant an appropriate order, making him a relevant person? Effect of which was to make him a relevant.
Counsel for the principal reporter in the First Division did not, as I understand it, suggest that under no circumstances should the appellant in this case ever be awarded parental responsibilities and rights. As I understand it, what was suggested was that being the particular matter at issue in the Sheriff Court case, because Crave 1, of course, seeks a full parental responsibilities and rights order, was a matter primarily for the Sheriff. And I think that's what's behind paragraph 70. Now, what then happened in the Sheriff Court was that the 5-day proof set down for the February was not litigated. It was discharged. Somebody said that 10 days were required. And on the 2nd of February 2010, the Sheriff, on what was then an unopposed motion, discharged the diet of proof and allowed a 10-day proof. And, of course, the fact that 10 days were set down suggests that this was very much to be a full examination of all the allegations and counter-allegations. And then ultimately on the 11th of May, or not ultimately, sorry, the next interesting chapter is that on the 11th of May this year, the father, the appellant, sought to discharge the 10-day diet of proof. But that was opposed by the mother and the curator ad litem, and Sheriff Platt refused it in hoc statu. He assigned a pre-proof hearing, but then the father came along on the 24th of May and moved a motion to discharge the 10-day proof. So the father wanted, the appellant wanted not to litigate at that time. That was opposed, but ultimately it was granted ex proprio motu. So the forum for contestation of the substance of the dispute was the Sheriff Court. The Sheriff Court was able to hear it, willing to hear it, fixed a proof to hear it. And it's not been heard because the proof has been discharged. In my submission, that leads me to compatibility because I say that the appellant has not been excluded. And one must be, in my submission, be very careful to use the word excluded only where there is an absolute ban or prohibition or a bright line exclusion, rather than where someone has a gateway, a filter through which they can enter
A hurdle,
process.
perhaps.
The word hurdle may be used. It may have more of a pejorative content than a filter or a gateway, which are more user-friendly, perhaps.
Better than a hoop, perhaps.
Better than a hoop. Oh, definitely better than a hoop. But whether it is a hoop or a hurdle or a gateway or a filter, what matters in my submission is, well, let's examine the hurdle or the gateway or the filter or the hoop and see whether it creates problems, see whether it leads to a violation of someone's Article 8 or Article 6 rights. And that's what we're dealing with here in my submission. Now, turning to issue 2 substantively then, the provision that is said to be ECHR incompatible is section 93(2)(b) of the 1995 Act. And it's said to be incompatible because, as I understand the argument, this 2-stage process, gateway, filter, hurdle, hoop, etc., that requirement, it is said, amounts to a violation of his Article 8 rights. And the focus, I think, was very much on Article 8 and the procedural requirements of Article 8, and I can understand that. In the written case for the appellant, it's described as an irrational hurdle. Because it said Article 8 requires no more than a de facto family tie. But of course, when one is dealing with a de facto family tie rather than a tie by operation of law, the simple case of the married mother, whatever it might be, then in my submission, that leads to a requirement to have a forum in which that tie can be established as the prerequisite to moving to stage 2.
Do all married fathers automatically have family life with their children for the purposes of Article 8?
All married fathers have parental responsibilities and rights in terms of Section 3. And
Look, I know that. I asked you a different question. Sorry, Miss White. I asked you whether all married fathers automatically had family life with their children for the purposes of Article 8.
Prima facie, yes, but there are circumstances in which, on examination of the facts, the right to engage in that family life may be removed by the court. So just as a married mother or an unmarried mother can be deprived of her parental responsibilities and rights if she has perhaps acted in a way severely detrimental to the child's welfare.
Can you deprive mothers of their parental responsibilities and rights?
Yes.
Can you? In Scotland,
Yes.
you can.
I wonder if it might be helpful just to...
I suppose section
Section
11
Section
would
11,
allow that,
yes.
yes.
Yes. And one of my arguments is going to be that there is a gender neutrality in much of this, and that the only place that there isn't a gender neutrality is in Section 3, which is not attacked. And that comes back to a point perhaps my Lord Roger made that I want to look at, because it is my submission that if one faces up to this, it is Section 3 that creates the difference in treatment. Now, that's jumping on a little bit, but...
Section 3.1a. Is it 3.1a? It gives the rights to the mother.
Yes, yes. But those rights can be taken away. The parental responsibilities and rights can, of course, be removed by the court in a Section 11 order. Now, as I understand it, the main points of attack were whether there was a legitimate aim for requiring this gateway or filter, and what is said to be the absence of a pressing social need. The respondent's position is this, that the requirement, if I can call it that, in Part 1 of the 1995 Act is consistent with Article 8 because it does no more than recognise the practical distinction that has long been recognised between natural mothers and fathers. So unmarried fathers may have a de facto family tie, but because, and this is referring back to McMichael, and I make no apology for that, they have to take the step of establishing that. It will be very easy to do in many, many cases. But that is the distinction. That's always been the distinction. It is in the primary legislation of England, Northern Ireland, Scotland, and has been specifically approved, of course, in the case of B against the United Kingdom, which I'm going to come to, in terms of a difference in treatment. So there is
that you say is the legitimate aim, the
Yes.
fact that it is enshrined in tradition.
But in fact, this is the initial allocation.
Yes.
This is the initial allocation, which is not under attack, because it doesn't have to be under attack. But of course, the consequences can vary. Now, I'm not entirely sure of the position in Northern Ireland, but I think it's the same as the position in England and Wales. No father, whether or not he has parental responsibility, is denied a part in proceedings about the future of his child, should he wish to exercise that. So they're automatically parties to care proceedings, which are the equivalent of what goes on in children's hearings. So there is no initial filter in England and Wales, or I believe in Northern Ireland.
Right.
Yeah. And apparently half the population of fathers, were it not for the fact that the registration has been introduced in Scotland, an initial filter would be regarded as necessary for half the fathers in Scotland.
Well, of course, there are a number of ways in which the father who's not married to the mother can obtain parental responsibilities and rights. It's not necessary to go to the court if there is a Section 4 agreement with the mother. And that was something, in the time of McMichael, there was no possibility for a Section 4 agreement. That was an innovation of the 1995 Act. So the comments in McMichael about the consent of the mother have to be seen in that context. But, my lady, I agree entirely that that's the nub of the issue. My argument is that it is not a violation to have such a process or such a requirement.
Well, there is an interference. You accept that, do you?
In a case where Article 8 rights are established, there's an interference.
Yes.
So the mother's Article 8 rights are inevitably interfered with once there are child protection proceedings under Part 2. The father is the unmarried father is in a situation where he has to establish the tie, the family relationship, and if he does so, then his Article 8 rights will be interfered with, but I say that is in accordance with the law and justified and the legitimate aim of child protection.
Well, could you say in a sentence, what is the legitimate aim for the interference?
That's the difficulty.
The legitimate aim is probably best summarised at paragraphs 40 to 42 in the respondent's case.
The trouble about 40 is, of course, the fox has been shot by the Act which allows them in now. So later, if it had happened with children after a certain date, I mean, all these fathers are in. So, I mean, the place must be crowded with fathers. I mean, why are you just keeping these ones out?
Yeah.
I mean, that's the difference.
Another way of putting it.
Well, the Lord Advocate, I think, tells us it's in the interests of legal certainty.
Yeah.
Isn't that the
How did the
point?
legitimate aim become illegitimate?
Yes.
Well, in my submission, the Lord Advocate's point is a good one, and no doubt it's for him to develop, but I've heard to develop. But the certainty arises from registration in post-2006 Act cases because there is then something, a document that one can say that is how you assert it. For cases like this, where that Act is not operative because it wasn't retrospective, you still have the filter, just as you have for those who are not registered at all. So there has to be some, and this perhaps brings us to the very end of the argument and the suggestion that it should be any parent. If there is no filter, then everyone is in, no matter what the circumstances are, whether they are the indifferent father, the father ignorant of the child, the father who has indisputably behaved in a manner that he would be contrary to the child's welfare for him to be there. So it's a filter that's not intended to filter out great numbers of fathers, but it's legitimate in my submission because the whole policy is to have people at this private children's hearing designed to be sensitive and promote the welfare of the child who is in need of immediate protection because they wouldn't be there otherwise.
Well, I think I can understand the generality of the policy. It's the application to this particular category of person that's really an issue, isn't it?
Absolutely. And I say that the justification remains for the reasons set out in the respondent's case.
Why was it changed then? If this was a good justification, why did it change? Why did the Scottish Parliament change the law?
Well, I have to accept that there has been a change in the modus vivendi of the way people live their private lives, and that marriage is not an option that is sought and obtained by as many as it was previously. But the fact that had the legislation been retrospective, clearly there wouldn't be an argument, but the legislation isn't retrospective, and the effect of that is that this appellant is in the same category as the father who hadn't registered the birth. These are the categories that are left. But of course, Section 93(2)(b) also operates to exclude those who have had parental responsibilities and rights and had them taken away. And I think when we look at Article 14, this becomes apparent that it is not a sex-based filter as such. It is one of the categories of no automatic entry. And that is why in paragraph 40, I say, and it's from Laws related to consider, that the legitimate aim is still there because those being filtered out are not as a class unmarried fathers who either haven't registered on the birth or registered pre-2006. Those filtered out are those who, in accordance with the statutory attest, don't seem to have or have to show that they have an ability to be involved in implementing decisions about the child's life.
But the aim can't become legitimate simply because it's gender neutral or because it applies to others apart from the appellant. You've got to crystallise what is the legitimate aim that is being pursued here in order to address the question whether the interference is justified.
Well, I say that the legitimate aim of limiting the number of persons who can participate in the children's hearing, but having regard to such social change as there has been, remains a legitimate one.
That's what it comes down to.
That's what it comes down to.
Restricting the people coming into the children's hearing.
For the purposes of child protection.
Yeah.
Because
But you don't restrict any of the married fathers, do you? Unless they've had
their
all their parental rights and responsibilities taken away. I assume that's how you would construe relevant person. That if you have any of them remaining,
yes,
you can participate.
Yes.
So far as the reasoning behind the change that brought in the new category in 2006, just looking at the Lord Advocate's written case, that I'll be told about this later, it does look as though it was the result of a consultation process which was directed to improving family life in Scotland. So one could say it was a recognition of an Article 8 case to be made for them, to be brought in. And then one wonders why a distinction should be drawn.
In the majority of cases, an unmarried couple, if they are a couple living together and having a child and just choosing not to be married, will register the birth together. But of course, when we come to part 2, those couples will both be in the children's hearing because they have de facto care and control. So all you need to be in the children's hearing is to have de facto care and control of the child, to be living together. So we are dealing now with a very small group of people who do not live with the mother of the child, who either haven't registered the birth or registered prior to 2006, and whose family life tie hasn't been established either by order of court or by living with the mother.
That begs the question, if it is a very small group of people, is it a legitimate aim to exclude them? If the purpose of it is to diminish the number of people who are crowding the children's hearings.
It comes back to the welfare test and the aim of child protection. Section 16, which is the first section in Part 2 of the Act, of course, has the welfare test as the paramount consideration throughout those proceedings also.
But it's quite difficult. You said here family tie not established by an order of the court.
Yes.
But in this particular case, of course, there were interim contact orders before the matter ever got to the children's hearing at all. Yes. So, I mean, there was in the past exactly that kind of link.
And there are, on the facts of this case, there are many ironies, and one of them is the contact order and, of course, the decision of the extra division in Authority Reporter against S, which I'll come to, because it is important. I say that the decision in Authority Reporter against S supports my argument on the basic construction of the legislation, and the contact orders and residence orders are not orders for parental responsibilities and rights, and you have to be very clear about what orders for parental responsibilities and rights are. So a contact order isn't a parental responsibility and rights order, but the concern of the division was that it must give somebody a civil right in Article 8 terms, and that was why the legislation was read down.
So that's why the reporter was prepared to agree to that,
yes.
Is that it?
The fallback position, the secondary position of the reporter in the extra division in Authority Reporter against S was that if the reporter was correct on the domestic interpretation argument, which ultimately the extra division found that we were, but that there was nonetheless an Article 8 concern. It was really expressed as an Article 6 concern, but at the moment we're discussing procedural requirements for Article 8. Then the reporter could see that for those people in this situation who had gone and obtained a contact order, it was hard to say that they hadn't established that right in a way that should give them involvement.
And unless the contact order was still in force, wasn't it?
Where the contact order was still in force. Now, clearly an issue has been raised this morning about the possibility of has or had a contact order, and that is something I will address when I come to reading down. But that is the context of it, is that the reporter's perspective is that the aim is to have those who truly have something to say that's beneficial in relation to the children's welfare in a system that requires the restriction on the number of persons.
Supposing in this case that the sheriff had not got round to revoking the contact order before the children's hearing, and the children's hearing made its order and said that the supervision requirement and that there should not be contact.
Yes.
As I understand it, almost inevitably, people would have gone along to the sheriff, and the sheriff would have said, "Okay, I'm following that. I follow suit, and I revoke." Maybe just ad interim or whatever, not finally. Now, in that situation, as I understand, that would be quite a likely sequence of events, because the sheriff wouldn't actually maintain it if it was said. In that situation, would one not be saying, really, that would it be realistic to say that the children's hearing wasn't affecting the civil rights of the parties, of the father, the child?
I see that, and ultimately, of course, that was the concern of the extra division Authority Reporter against S. Yeah. Of course, the sheriff would still retain jurisdiction to make parental responsibilities orders. And I appreciate that's a slightly circular argument, but if the sheriff made a parental responsibilities order, of course, all that, as I understand it, the appellant is saying is that I should be in the children's hearing in that situation. So one can't argue with the suspension or revocation of contact in the child's best interests, and the only way in which either the hearing can suspend ongoing contact or the court can revoke contact is if it's satisfied on the welfare principle. But in terms of involvement in whichever process is at any particular time looking at child welfare, whether it's for immediate protection under Part 2 or the contestation of rights and responsibilities under Part 1, the sheriff never loses jurisdiction to make the order that allows the father into the children's hearing, and that's my central
practical effect, to answer, I mean, and this is how the thing operates, is I would take from Aiken, that the children's hearing would make a supervision requirement and say there shouldn't be contact, even though there was an existing contact order.
Yes, and they wouldn't be taking the contact order away, they would only be suspending its exercise.
I follow that, but yes. I mean, it would, it could suspend it for years, indeed. It could go on for the rest of the child's life.
Well, it can only suspend it for certain periods, and I think this is
a year at a time. How long is it? A year at a time. Sorry, I beg your pardon.
Yeah, but this is really back to the point about the sheriff court proceedings and the ability to litigate in that. And my Lord already had my submission on that. In relation to the issue of a filter, of course, it is not. It also exists in other in other legislation involving children, in particular in Hague Convention proceedings. Of course, one has to have a right of custody under Article 3. Before one can invoke the remedies to have the child returned to the jurisdiction of habitual residence. But that's a general point about filters.
Could I ask you a factual scenario which might be not at all uncommon? You've got an unmarried a couple who are actually on rather good terms. They're not living together. They're living in separate households, but they're sharing the parenting of their children or child, and the child spends a certain amount of time each week with Dad.
Yes.
There are no court orders. They don't see any reason to get a court order. In fact, it would be contrary to the no order principle that you have in your legislation, just as we have in ours, to get a court order, because there ain't no need for it. And then something happens which interests the social care department and a children's hearing is called. Would you say that Dad was able to participate in that hearing right from the word go?
On those facts, my lady, it would appear to me that they're probably both in under Section 93(2)BC.
Charge and
care and control, because they're sharing care and control of the child.
Yeah. Has charge of or control over, yes. So at what point does something flip over from being contact to being sharing charge and control?
I think it requires an individual assessment of the facts, my lady. But in the example given, I would suggest it would be caught by 93(2)BC.
So not cut and dried at all?
No, and one of the difficulties in if my lords and my lady were considering moving away from the existing terms and reading the legislation down, that raises that sharply into focus about who decides. And it is my submission that the court should always decide. That I refer to Aiken, I refer to P, and I say that the court is there, and the remedy, and I want to examine the remedy that can be invoked, and the fact that it can be invoked with ease, and has been invoked with ease time and time again in this very case, remains the appropriate forum in issues of contest.
Can I see if I could understand that? The words "who appears" are in head C, and you're saying appears to the court, are you?
No, I'm sorry, I moved on.
I mean, it's quite difficult to work this out in practice when you know that this is actually designed for use in connection with the children's hearing.
Yes, I'm sorry, my lords misunderstand me, and lady, it's my fault. Where there is a contest between the parents about welfare and whether certain rights should be bestowed upon a parent, then the court is the appropriate forum. I wasn't suggesting that the court should be interpreting 93(2)BC. I was suggesting that a reading down that required the children's hearing to be involved in such contests would be inappropriate.
But really, the sensible reading of this appears to the reporter. Would that be right?
Yes, and ultimately the hearing. In the course of argument, the counsel for the appellant concentrated on other statutory provisions that referred to parent and duties of the local authority in terms of parent, I think to support the contention that this was an unwarranted distinction, if you like, in 93(2)B. However, in section 17 of the Children Scotland Act 1995, and in particular, subsection 1 of 17, a local authority is there required to distinguish between parents who have and who have not parental responsibilities and rights. So that's 17.1, where a child is looked after by a local authority, they shall in such manner as the Secretary of State may prescribe, C, takes up such steps to promote on a regular basis personal relations and direct contact between the child and any person with parental responsibilities in relation to him, that would be parents or non-parents, as appear to them to be having regard to their duty to him under paragraph A above, both practicable and appropriate. So there is a consistency between the provision in 93(2)B that restricts entry to the children's hearing in a fully participatory sense to those who have these parental responsibilities and rights by operation of law or court order, and the obligations of the local authority to promote, insofar as practicable, personal relations and direct contact. And of course, if a sheriff had heard evidence and made findings that made clear that it would be in the best interests of the child for personal relations and direct contact to be maintained, then there is a specific duty on the local authority who are looking after the child to maintain that.
You would have to also decide that the parent should have parental responsibility.
Yes, and in my example, that would be the conclusion of the sheriff. Yes.
Well, it's quite a wide-ranging inquiry. If you look at subsection 3,
yes,
parents in general are brought in there.
Yes, that's in relation to ascertaining views, and of course it's not restricted to parents. It's a very general, and it looks to any person that the authority considers to be relevant during the matter to be decided. So it's not imposing a duty to do something such as promote a relationship. It is a duty to consult effectively. My Lords, my Lady, my principal submission on this point is that there is a fundamental distinction between the sort of bright line exclusion or blanket ban that arose for discussion in Re G adoption unmarried couple and cases such as the present case where a remedy exists in the form of an application to the court. And what I say falls foul of Article 8 and ECHR is where there is no opportunity, where a class of persons is excluded from obtaining the necessary remedy. Unless it can be said that all filters or gateways are incompatible in this context, then I say the structure of the 1995 Act is sound.
It doesn't have to be said that all filters are incompatible, because any filter would have to be rational, wouldn't it?
Oh yes, and in terms of rationality, I've explained what I say are the justifications for that. I wonder if I might ask my Lords and my Lady to look at in Re G, which is at tab 24, volume 2 of the authorities. Now, this case, as Lord Hope and Lady Hill will recall...
So tab, which, I beg your pardon?
24.
Tab 24, my
24,
lord.
thank you, sir.
Well, I remember the case very well, of course, Miss Wise, but none of
others
their
may not.
lordships will do so.
Yes, I
Well, I think
appreciate
I might
Lord
remember
Hope.
it. Yes,
You might remember
my
Ireland,
decision was reversed, I think.
Yes, yes.
More cause to remember it than most.
But in any event, the issue was, of course, the exclusion of unmarried couples from the adoption Northern Ireland Order, in particular Article 14 of that. And the difficulty was with a fixed rule that excluded unmarried couples at the outset,
Yes.
that they couldn't get in at all. There was a blanket ban or a bright line exclusion, as it was called. Now, I wonder if I might first ask my lords and my lady to look at Lord Hoffman's judgment at paragraphs 11 through to 18, but perhaps I'll just take small parts of them just to refresh or advise on the background to this. There, Lord Hoffman at paragraph 11 says eligibility, and this is in terms of the Northern Ireland Order, to apply for an adoption order is therefore only the first step on the road to adoption. The applicants must be thoroughly scrutinised to satisfy the court that adoption is in the interest of the child, and among other things, they'll be able to provide the child with a stable and harmonious home. But the effect of Article 14, that's of the Northern Ireland Order, is that even if the court considers that an applicant couple pass all these tests, that adoption by them is plainly in the best interest of the child wishes to be adopted, the relationship is loving, stable and harmonious, their virtues else be they pure as grace, as infinite as man may undergo. Nevertheless, the court is bound to refuse the order and take a course which ex hypothesi is not in the best interest of the child on the sole ground that the applicants are not married. So where you have an exclusion of a class of persons, regardless of what the welfare test would demand, there is a problem. Then at paragraph 13, over the page at 182, Lord Hoffman goes on, and he records the arguments in support of this exclusion that were given. And he says, I would agree that at the macro level, these are good arguments. The state is entitled to take the view that marriage is a very important institution and that in general it is better for children to be brought up by parents who are married to each other than by those who are not. If, therefore, it was rational to adopt a bright line rule to determine what class of people should adopt children, there would be much to be said for Article 14. There's ample authority for the proposition that for administrative or other reasons, social legislation may require such bright lines to be drawn. And then they cite passages on that. But, of course, this isn't a bright line case, which is my argument. Over at paragraph 16, he goes on, the question, therefore, is whether in this case there is a rational basis for having a bright line rule. In my opinion, such a rule is quite irrational. In fact, it contradicts one of the fundamental principles stated in Article 9 that the court is obliged to consider whether adoption by particular persons will be in the best interests of the child. A bright line rule cannot be justified on the basis of administrative convenience or legal certainty because the law requires the interests of each child to be examined on a case-by-case basis. And I say the distinction is that, of course, bright line exclusion is problematic and can't be justified, but a rule that is simply a filter or a gateway is in a very different category, particularly when the overriding requirement to have the child's interests as a paramount consideration is taken into account. And then over at paragraph 18, Lord Hoffman goes on, it's one thing to say that in general terms, married couples are more likely to be suitable adoptive parents than unmarried ones. It is altogether another to say that one may rationally assume that no unmarried couple can be suitable adoptive parents. Such an irrebuttable presumption defies everyday experience. So again, the distinction is drawn between the rule, as in this case, where certain persons automatically by operation of law have parental responsibilities and rights, and others require to apply to the court, but they can apply to the court, they're not excluded. Now, my Lord Hope, at paragraph 54, in this context, of course, referred to the Scottish decision in T petitioner, as at paragraph 54, after reviewing some of the European authorities. And that was the case where, at that time, there was an issue about whether a homosexual couple could adopt a child. There was no question of them being able to adopt as a couple, but one of them had put forward the petition. And the matter went before the First Division, who said there can be no more fundamental principle in adoption cases. It's the duty of the court to safeguard and promote the welfare of the child. Issues relating to the sexual orientation, lifestyle, race, religion, or other characteristics of the parties involved must, of course, be taken into account as part of the circumstances, but they cannot be allowed to prevail over what's in the best interests of the child. In other words, the primary rule is best interest, and if anybody is excluded from asserting that what they want is in the best interests of the child, that would be improper. And my Lord Hope went on to refer to one of the written cases with approval and say that eligibility simply opens the door to the careful and exacting process that must follow before a recommendation that's for adoption is made. The interests of the child require that this door be opened as widely as possible, otherwise there would be a risk of excluding from assessment couples whose personal qualities and aptitude for child rearing are beyond question. So I say in this case the door is open. The door is fully open. My lady then looked at the matter in some detail, and the important passages for present purposes, I think, start at paragraph 113 under the heading of the Strasbourg margin of appreciation, dealing, of course, there with the exclusion of a whole class. My lady there sets out that, of course, states are free but not required to extend the scope of the convention to same-sex couples, and there's a discussion about same-sex couples. And it's recorded, of course, at the bottom of paragraph 113 that there is as yet no consensus amongst the member states of Europe on these issues. And when we come to Zauninger, we see that on a comparative exercise they come to the same view. At paragraph 115, my lady then opined as follows: but it is by no means so clear that the Strasbourg court would send the same message if an unmarried couple were refused permission to adopt jointly simply because they were unmarried. It is possible that Strasbourg would regard this in the same light as discrimination between children of married and unmarried parents, or between married and unmarried fathers. But the latter can sometimes be justified, and there's a reference there to McMichael against the United Kingdom in this context. Differences in treatment between married and unmarried couples since tax and social security systems have been allowed. A reference to Shackle against the United Kingdom, where it was said that marriage remains an institution which is widely accepted as conferring a particular status on those who enter it. Strasbourg might well be prepared to grant member states a wider margin of appreciation for differences in treatment on this ground than on the ground of sexual orientation, particularly where the couple were free to marry but chose not to do so. And then there's a reference to the article of the Irish Constitution that states the state pledges itself to guard with special care the institution of marriage on which the family is founded and to protect it against attack. It is possible that Strasbourg would regard the special constitutional protection of the marital family under that constitution as justifying the continued restriction of joint adoption to married couples. On the other hand, it's possible that Strasbourg would be unconvinced that the restrictions serve to protect marriage from attack, reference to Karner against Austria. In the United Kingdom, of course, we have no such constitutional protection for marriage, although we do still regard marriage as the best legal environment in which to bring up children. And therefore find myself unsure as to whether Strasbourg would regard this in the United Kingdom's margin of appreciation. And then, of course, at paragraph 123, my lady went on to describe what was in the Northern Ireland order as a blanket ban, and I respectfully adopt that description for the distinction between that order and the legislation we have in this case. If the unmarried father was not allowed in, if he didn't have a simple, effective remedy to get into the children's hearing, then the same problem that arose in Ray G would arise, and I say it doesn't. And I also say
Not all
that
fathers are maybe avid for litigation in the sheriff court. I mean, it's quite an undertaking. I think that's one of the points which is made against you. But I mean, if one sort of went, we have to think about the interests of the child here, because as I understand, one of the points which is made by the curator is that it's really in the interest of the child to have the father there. Now, the child can't open the door. The father may be a somewhat reluctant person to go off to the sheriff court, and it's quite an undertaking and so on. I mean, is that something we should be thinking about?
well, I say there may be a difference between the circumstances in which it's in the interests of the child. So it won't be in the interests of the child in every case.
No, but I mean, you don't get rights and responsibility. You don't get the right unless it's to discharge the responsibility. And that's the odd thing about the Scottish legislation, is you don't actually have any rights to see your child unless it's in the interests of the child. I mean, that's the thing. But I mean, but it's, assuming that that's right, but I mean, I'm just thinking of it from the point of view of, I mean, it is quite an undertaking. I think even you would agree with that.
Regretfully,
No,
Lord, with the
maybe
greatest
not.
of respect,
You
I
wouldn't.
do disagree with it, because
Not
it is a plank of the respondent's case, and this is in the recent case also, that this is not a huge undertaking, that it's simple, that it's quick, that it's effective, that legal aid is easily available, that the child welfare hearing system that we've heard so much about over the last 2 days requires the sheriff to look at these matters at an early stage in the proceedings, to see who's there, to see what the contestation is, and so on and so forth. The availability of the orders and the lack of onus that was referred to by you, my lord, in White Against White, also serves to show that all that matters is to see what material there is and to see what the welfare of the child demands, which was an expression my lord used in an earlier case of Osborne against Matan, which wasn't involved in this context. So I say no, far from being onerous. I say this is a simple remedy. Now, that is what the First Division also said, and I say with good cause. So I do respectfully disagree with that. Now, on this question of blanket exclusion or irrational hurdles versus what I say is a simple and effective remedy, and thus proportionate, because clearly the question of proportionality is important. In my submission in this context, although it's primarily an Article 14 case, the case of Zaunegger against Germany is of considerable interest, and that is found at tab 73.
That's the back of 6, is it?
Yes, volume 6. I think it's the last authority in volume 6. This was the case where a couple weren't married, and the father went to the district court in Clone and wanted a joint custody declaration, but it was refused because the German code, the civil code, required that the consent of the mother was required before the court could make an order of joint custody, or as we would say, joint parental responsibilities and rights. And the case of Zaunegger, rather like the case of Sahin, turns on this problem of the mother's veto that the German code had. And in my submission, the giving one party a veto does give rise to problems in a way that what I call the filter does not. Because in our legislation, we trust the court to apply the welfare principle and to make an order no matter the opposition of the mother. Now, in Zaunegger, at paragraphs, and I'm very conscious of the time, I'm very conscious that the court will be anxious to hear from counsel
Yes.
for the Lord Advocate and the mother. But at paragraphs 22 to 27, my lords and my lady may simply wish to record that there's an interesting analysis of the comparative law of the various member states. And in essence, what the court found were that there were a few countries where this veto by the mother or the requirement for consent was prevalent: Austria, Norway, Serbia. And that is, and Germany, of course, and that is where Zauniger fell foul of the convention. Now, my learned friend Mr. Scott already has referred the court to paragraph 60, and I say that paragraph 60, and this was really in connection with Article 14, but of course it's the operation of Article 8 and the ability to go to the court. Paragraph 60 on page 965, the court reiterates that the convention is a living instrument which must be interpreted in the light of present day considerations. Well, one can't quibble with that, but that does not mean that somehow McMichael, referred to in a number of recent cases, is outmoded or no longer applies. The court observes in this context that although there exists no European consensus as to whether fathers of children born out of wedlock have a right to request, and I say those are the operative words, joint custody even without the consent of the mother, the common point of departure in the majority of member states appears to be that decisions regarding the attribution of custody are to be based on the child's best interest, and that in the event of a conflict between the parents, such attribution should be subject to scrutiny by the national courts. And I say that that squarely supports the contention that I make, that on the one hand, if there is no right to request the court, that must be a violation. The Scottish legislation is far removed from a blanket exclusion or an inability to make a request of the court. And then the question does become, well, what's the nature of the remedy? And my lords and my lady have my submission on that, and I say that it can, as we see in the facts of this case, be done with ease. And I'm going to try and not take lords and my lady to many more authorities or references, but if they could just be noted in the respondent's case at pages 17 to 18, there are examples listed of the numerous orders obtained by this appellant in the Sheriff Court action. And I say that all that this appellant and many others have to do is invoke the appropriate remedy. There's a right to apply.
Can I be quite clear what you're referring to? You said pages 17 and 18, did you?
17, I think 17 and 18
Yes,
of
that's
the
right.
respondent's case.
The orders.
Of the respondent's case.
These are the orders.
It's a list of the orders obtained
Yes.
and that goes to the nature of the remedy and whether it can be done with ease, and the system of interim orders and the system of child welfare hearings. Where a father who asserts a de facto family tie as opposed to one by operation of law, there are of course numerous situations in which any Article 8 rights established must yield to the best interests of the child. And I don't think there will be any argument with that, and so I don't want to take up more time with it. The references are in paragraph 43 of the respondent's case at page 20, and the references there are to cases such as K&T against Finland, which is a child protection one, Bronda against Italy, Esholz against Germany, and there are passages referred to there about the yielding where the best interests of the child demanded. And of course Sahin was important also in this context, where there was no standalone violation of Article 8, albeit that Article 14 came into play, and I'll come to that in a moment. So the procedural protections are there, I say, in Article 8. It's suggested, I think, that the First Division erred in failing to have regard to the issue of delay in the context of Article 8, but I say that the chronology of events in this case belies the contention that the requirement to secure an order in the Sheriff Court results in delay. And again, I don't want to take time by giving any more examples of that. I wonder if I may turn now to make a few further comments about Article 14 and then to address the question of reading down. And
yes.
I'll do so as expeditiously as I can, but...
I don't want you to rush too much. It's very important we
yeah,
get your
well, I see that. I'm conscious of
Yes.
the others needing to be heard. So far as Article 14 is concerned, the appellant argues that the First Division erred in failing to realise that a difference in treatment is discriminatory for the purposes of Article 14 if there is no reasonable relationship between the means employed and the aim sought to be realised. And this brings us back to the argument about whether any difference in treatment is justified and whether Section 3 is really what's behind this. Now, there is, of course, to my knowledge, no ECHR jurisprudence to the effect that no difference in treatment can be justified. And again, the reference to McMichael and Ray G. But B against the United Kingdom, which I don't think, my lords and my lady, have been taken to yet, is important in this context. It's tab 56 at volume 5.
Sorry, which tab, please?
56.
56, thank you.
56. So this is B against the United Kingdom, and this was an unmarried father applied for parental responsibility in a contact order under the English legislation, which for present purposes it was at the time identical because it gives the mother parental responsibilities and rights and the unmarried father not.
Only identical in relation to the initial allocation.
In relation to initial allocation.
The meaning of parental rights and responsibilities is different, as we gather, and there's no limitation on access to the courts.
Indeed, and I refer to the case primarily for the reference again to McMichael and the objective and reasonable justification for a difference in treatment. And perhaps all I require to do is invite my lords and my ladies to look at pages 5 and 6, just under where Article 14 is set out. The court says the following. The court recalls that Article 14 of the Convention has no independent existence, etc. For Article 14 to become applicable, it suffices that facts of a case fall within the ambit of another substantive provision, and here, of course, we're dealing with Article 8. The court considers that since the applicant complains of discrimination in the protection that national law gives to his relationship with his child, the facts of the case fall within the ambit of Article 8 of the Convention. Although the applicant complains of discrimination between married and unmarried fathers, the court notes that the domestic courts which examined the applicant's applications did not make reference to the fact that he was not married to the child's mother. They only referred to the fact he didn't have parental responsibility. It is true that under the Children Act 1989, the English legislation, married fathers have parental responsibility automatically, while unmarried ones need to acquire it in accordance with the provisions of the Act. However, the court has considered that the relationship between unmarried fathers and their children varies from ignorance and indifference to a close, stable relationship indistinguishable from the conventional family-based unit, and there's a reference there to McMichael. For this reason, the court has held that there exists an objective and reasonable justification for the difference in treatment between unmarried and unmarried fathers with regard to the automatic acquisition of parental rights. So there's a more recent reference to McMichael and the difference in treatment, and my respectful submission is that it matters not what proceedings one is in, because the requirement, as per McMichael and the 1995 Act subsequently, is that you don't get parental responsibilities and rights by operation of law if you're an unmarried father. So I say that is why this is squarely in point in this context. And of course, McMichael was a child protection case. It was a case when one was dealing with access to the children's hearing. In any event, there's the court goes on about discrimination, but that was the main passage. I think there's a reference to Hague Convention proceedings and custody rights, and I alluded to that earlier, my lords and my lady. And then towards the end of page 6, in these circumstances, the court considers the domestic court's refusal to interpret the notion of their custody powers so as to place the applicant on an equal footing with a father having parental responsibility had the same objective and reasonable justification referred to above, namely the different responsibilities borne by fathers who have the child in their care and fathers who do not. And that goes back to the argument that I've rehearsed several times in relation to care and control in the different situations, and therefore the differential treatment under domestic law of the applicant and a father with parental responsibility didn't disclose an appearance of violation of 14 read with 8. Now, it is my submission that the provisions then of 93(2)(b) can be seen to be gender neutral and status neutral. It is section 3 that, on one view, is not. The focus of 93(2)(b) is to give those who have on the face of it a requirement to participate in the system because of their connection with the child to make them relevant persons. And it cannot be stressed enough in my respectful submission that all of those who have the charge or care and control of the child will always be in this category, married or not, parental responsibilities or not. The First Division in this case pointed out that it was section 3 of the Act that creates a difference in treatment, not section 93(2)(b). And I would simply refer to paragraph 72 of the First Division's decision where that is recorded. And I would respectfully suggest that that is correct, that it is not section 93(2)(b) doesn't create a gender bias. In my submission, when the First Division asserted that the absence of a bright line exclusion, but instead the creation of a gateway or a filter, didn't carry an implication of discrimination, that was correct under reference to INRAG. My Lord, my Lady, I'm very conscious of the time. I'm not going to be able to finish. I am near the end of Article 14.
I
but
wouldn't
as I'm
expect
not
you to. You asked for 3 hours, and you haven't actually exhausted that time yet. Might I suggest, when the others are considering how much time they need to address us for, that they should have regard to Ms. Scott, who may want to make some submissions in reply, and perhaps you could discuss this amongst yourselves about how you allocate the time.
Of course, my Lord,
But we're very anxious not to rush people if that can be avoided.
I'm obliged.
See you at 2 o'clock.